Hello, everyone. My name is Michael Sheridan. I'm a partner with Bond Schoeneck King's collegiate sports practice. I've been with the firm for a little over 5 years, specializing in NCAA compliance and infractions matters. And prior to joining the firm, I spent about 9 years with the NCAA's enforcement staff, where I investigated and processed major infractions cases. I've also worked as an on-campus NCAA compliance officer at two Division I institutions and practice as a criminal defense attorney. My colleague Michael Barnett is senior counsel at Bond and joined the firm's Albany office this past November. Prior to joining the firm, Michael was an assistant United States attorney in Albany for nearly 11 years, focusing primarily on fraud and tax prosecutions. Next slide. I'd like to give a quick rundown of the topics we'll cover this afternoon. Michael and I will discuss and review the current federal and NCAA investigations involving collegiate men's basketball, NBA basketball, and Major League Baseball. Michael will address the Department of Justice legal theories and relevant statutes in those federal prosecutions, and I'll discuss the NCAA's relevant bylaws and procedures. We'll distinguish between federal and NCAA investigations. We'll talk about institutional response options if law enforcement and/or the NCAA were to come to your campus, as well as the rights and cooperation responsibilities of schools and individuals like coaches and athletes. We'll also discuss the rights and cooperation responsibilities, as well as what you all can do to prepare today and plan today in case one of these investigations come to your campus, as well as best practices. And if there's time remaining, we'll discuss some miscellaneous items, including the impact that these investigations can have on your NIL and rev share contracts, transfer recruitment considerations, and sports betting integrity services and the prediction markets that are seeking entry into college sports. And again, you're welcome to submit questions via the Q&A function. Next slide. So for an overview of what's currently happening, in the United States, there is legalized sports betting in 39 states plus the District of Columbia. And several states are actively pursuing legalized sports betting, including Nebraska, Georgia, Alabama, Minnesota, South Carolina, Texas, and Hawaii. I'll turn it over to Michael to talk some of the current federal investigations.
When we planned this webinar, we had in mind the federal indictments arising from the NBA and Major League Baseball. And this webinar now cannot be timelier because last week we all saw the news of an indictment issued out of the Eastern District of Pennsylvania alleging a very large sports gambling corruption scheme. This case is United States versus Jalen Smith et al. And the allegations are that during the 2023-2024 men's college basketball season, more than 39 players on more than 17 teams across the country fixed and attempted to fix more than 29 games. Defendants in this case in Philadelphia federal court are charged with bribery in sporting contest, wire fraud, conspiracy, and wire fraud. The allegations in sum and substance are that players were recruited basically across the country. Just to take a step back, the indictment alleges this kind of core group of sports gamblers who recruited men's basketball players across the country. These players were bribed in order to fail to cover the point spread for either the game's first half or the entire game. So meaning these players may have been on a team that was actually predicted and favored to lose by 10. And these bettors basically paid some of these players, let's say, to try to lose the game by more than 10 points, which would allow these bettors to win on their bets. That is essentially the gist of these allegations. And basically, this group of bettors are alleged to have done this across the country, paying and bribing many players on many teams. Bribe payments usually range from $10,000 to $30,000 per game. The indictment notes that the targeted teams were often underdogs, meaning they were already favored to lose. and the targeted athletes, meaning those who were paid these bribes, those bribes were significant in terms of the amount when compared to the NIL payments that these student athletes were legitimately receiving. The athletes are alleged to have intentionally performed poorly during these games and also to have removed themselves from games. The indictment also alleges that cash payments were delivered to players on or near campus. And again, this was during the 2023 to 2024 season. Some of you might be wondering, well, why, if this involves alleged corruption across the country, was it brought in Philadelphia federal court? If you read the indictment, you'll see that there are a lot of different connections as alleged to Philadelphia, including that some of the bettors placed their bets while in Philadelphia. And also there was travel through the Philadelphia airport in connection with the scheme. And also there was one fixed game that took place in Philadelphia. So generally in federal cases, they can be charged in any district where some portion of the alleged events took place. So that's why this case is charged in Philadelphia federal court, even though the activity involved ranges across the country to include both coasts and a lot of games actually in the Midwest. Next slide, please. So as I said, when we were planning this webinar, we were actually focused on the two prior cases. And so I'll only briefly describe those. These cases arise out of professional sports, and both of them are in the Eastern District of New York in Brooklyn Federal Court. There's one that arises from alleged fixed NBA games. This is United States versus Ernest et al. This is the one where Terry Rozier is a defendant. For instance, there's an allegation that the conspirators bet the unders on Mr. Rozier's player props, meaning they bet that he would not reach a certain amount of points, a certain amount of rebounds, a certain amount of assists, while knowing that he was going to exit the game prematurely and not because of a legitimate injury. Chauncey Billups is not a defendant in this case. However, he does appear to be referenced in the indictment because there's an allegation that one of the conspirators placed bets because they received inside non-public information from Mr. Billups that the Trailblazers, which Mr. Billups coached at the time, would be purposely tanking a game in order to increase the chances of a better draft pick in that year's lottery. So that's the NBA indictment. There is also a Major League Baseball indictment. This is in Brooklyn, but it involves Cleveland Guardians pitchers who are alleged to have taken bribes in connection with prop bets, meaning that people were actually betting whether these two pitchers would throw a ball or a strike for a given pitch. And the allegation is that these players were bribed and in return told their co-conspirators exactly what kind of pitch they would be pitching. And there were also pitch speed prop bets, meaning let's say there was a bet that this pitcher would throw a pitch under 95 miles an hour. These bettors are alleged to have placed bets knowing full well, because they bribed the pitcher, that the pitch would come in under that target speed. So that's the Major League Baseball indictment. I note here that the legal theories in this case are untested, meaning the statute used in the college basketball case, bribery in sporting contests, and then the statutes used in the other cases I've mentioned on a services fraud, wire fraud, these are rarely applied to the factual scenarios that are actually laid out in the indictment. And this is not uncommon for Department of Justice prosecutions. AUSAs, assistant U.S. attorneys, are often very aggressive. They take generally applicable statutes and apply them to new fact patterns. And what happens is usually a defendant will, or more than one defendant will, challenge the use of the statutes in this context. The district judge has to make an initial call are these crimes? Is the use of these statutes permissible? And then eventually the question of whether these statutes can be used in this context, it makes its way up to an appeals court and eventually up to the Supreme Court. And that's all really to say that as of right now, we have no idea whether the theories set forth in these indictments will actually be upheld by appellate courts and the Supreme Court. The fact of the matter is that until we get clarity from those courts, these investigations are very much here to stay. I anticipate many more of them, including in the collegiate sports context. And so these are investigations that universities are going to have to reckon with for years to come. Back to you, Mike.
Thanks. I'll touch on some of the same types of points as it relates to the NCAA's investigation into men's basketball. So in terms of the applicable rules, actually, could you go back? Thank you. NCAA rules prohibit individuals like coaches, administrators, student athletes, and other athletics personnel in general from betting on any sport, whether collegiate or pro, in which the NCAA puts on a championship. So basically, the only sporting events that would leave for permissible betting would be things like horse racing or auto racing. Now, there was an effort last year to deregulate NCAA rules as it concerned betting on professional sports, but that effort ultimately failed. And so for now, the traditional prohibition on all forms of sports betting is in place. And NCAA investigations into sports wagering activities typically fall into one of two categories. And this is the vernacular that the NCAA will use. The first is prohibited bettor cases, and the second type is integrity cases. Regardless, these two types of cases implicate NCAA sports wagering rules and Bylaw 10, specifically Bylaw 10.3. And prohibited bettor cases are instances in which someone who is subject to NCAA bylaws, so a coach or an athlete or an administrator, places a bet on a sporting event where they do not necessarily have personal involvement or influence in that game or outcome. So, for instance, an assistant baseball coach on your campus places a bet through FanDuel on the Super Bowl. That's a violation of Bylaw 10.3, as the assistant coach is a prohibited bettor, someone who's not able to permissibly gamble on that type of activity. Contrast that with these integrity cases, which entail a situation where an individual who is subject to NCAA bylaws, like an athlete, taking some type of action that would compromise or influence the integrity or outcome of a contest. So point shaving is an example of an integrity issue. Players underperforming to win a first half under bet would be an example of an integrity issue. A coach or player taking themselves out of a game in furtherance of a bet would be an integrity issue. And in terms of how the NCAA enforcement staff views prohibited bettor versus integrity cases, I think it's safe to say that integrity cases are considered more serious. That's not to say that prohibited bettor cases are not serious, but I think integrity cases take on an additional layer of seriousness. For instance, the starting point for integrity-related violations for an athlete is permanent loss of eligibility. I'd like to talk a little bit about some of the recent gambling cases that have been adjudicated by the NCAA. The University of San Francisco is one such case, which involved a men's basketball athlete sharing insider info or kind of team-specific information with a student athlete at another school who then used that information to place a prop bet. Temple University is another case. One aspect of that case involved two men's basketball staff members placing bets on professional and college contests that did not involve Temple. So that would be your example of a prohibited bettor violation. The Temple case also involved one men's basketball athlete placing bets involving Temple games, betting for and against his own team, which did constitute an integrity issue. Mississippi Valley State involved two men's basketball student athletes engaging in game manipulation activities, specifically by providing information to outside bettors who were engaged in sports wagering activities, information that they then used to bet on Mississippi Valley State to lose by more than the point spread. So that would be an integrity issue. And last, the University of New Orleans involved 3 men's basketball athletes engaging in game manipulation activities that also involved outside bettors. So you see some commonalities to these cases, the use of outside bettors, people who are trying to ingratiate themselves with athletes for insider information, and then even trying to influence the athletes to take action that would actually influence the outcome. Additionally, at present, several Division I men's basketball athletes are under investigation by the NCAA for integrity-related issues, including engaging in sports wagering activities in which they personally competed. And Michael touched on this briefly, but I'll just underscore it. The general profile of these investigations that have been reported on publicly, including these adjudicated cases, appear to center on student athletes at the mid and lower levels of Division I men's basketball. And those teams are often having average or even losing seasons and manipulating games such as, taking action towards first half under bets where a player or players will underperform in the first half of games to steer the outcome toward the under of the total points for that first half. A few other notes before we move on. There are instances in which prohibited bettors will use the online betting accounts of another person in their life to place bets, like a significant other or a friend or even a family member. Also, sports betting operators and integrity services are very sophisticated at monitoring and tracking this type of activity, including using another's account and maybe sharing their information with the NCAA and other regulators in furtherance of investigations. Next slide, please. Next, Michael and I will distinguish a little bit between NCAA and federal investigations into this type of activity. And I think we'll start with the obligations to notify the institution or the involved athlete. NCAA bylaws require the NCAA enforcement staff to provide formal notice, typically in what's called a notice of inquiry, which is codified in the NCAA manual in bylaw 19.6.2, that the enforcement staff has initiated an investigation and will be coming to campus. And the NCAA is required to provide this notice before coming to campus and conducting on-campus interviews. Now, however, with that said, the enforcement staff can do some limited investigative work that would be specific to your institution and your athletes before providing such notice. And that typically would take the form of working with anonymous or confidential sources, interviewing individuals who are not associated with your institution, or collecting documents or data from third parties. The NCAA's responsibility to cooperate is codified in bylaw 19.2.1, and the failure to cooperate bylaw is codified in 19.2.2. And these are some of the most useful tools that the NCAA enforcement staff has in its toolkit. And failure to cooperate for either the institution or an individual can include serious penalties, including for an athlete, loss of eligibility. Before I go further, I'd like to give Michael a chance to talk about the notice requirements as it relates to federal investigations.
Yeah, so it's very different with respect to federal criminal investigations. Federal agents have no obligation to announce their intention to visit campus ahead of time, for instance, and often they want to catch people by surprise because in their minds, it will increase the likelihood of getting someone to speak. An agent isn't going to go into a private campus building. They're not allowed to trespass, but the scenario that I envision and which I think general counsel offices need to be aware of is, for instance, an agent that wants to question an athlete or another student as he or she walks from their dorm to class or from class to the gym, across campus, across the quad. It's in those scenarios where an agent might introduce themselves to the athlete or to the student and might try to get in a quick conversation right then and there, again, without providing any prior notice to the institution. And as a prosecutor, as someone who's worked with federal agents, I know that this is something that agents do all the time. every day, every week. They always want to maintain the element of surprise because in their mind, that increases the chances of someone actually speaking to them. On the other hand, there is absolutely no obligation to speak to federal agents in such scenarios. If you are subpoenaed to grand jury, you generally have an obligation to testify unless you're asserting some kind of privilege, and we'll get to that later. But in terms of whether someone ever has an obligation to speak to a federal agent, the answer is no, they absolutely do not. And what concerns me, thinking through these issues from the perspective of someone who might be in a general counsel's office, is that the people that might be approached in these investigations, they're going to be younger people who are 18, 19, 20, 21. They might not be that mature. They might not be that savvy about their rights. They might think that they have to speak to federal agents. And, in that moment, surprised by the person speaking to them, they might actually choose to speak, which creates a multitude of issues, to include, one, the fact that the person could be admitting to either criminal conduct or other types of misconduct, for instance, NCAA rule violations, or they might be lying to the FBI agent, which is in itself a crime that can be charged. So I think this is a very fraught issue, and especially when contrasted with the NCAA approach, the issue of federal agents coming onto campus to question people by surprise. It is something that I would be very concerned about in this context. Mike?
Yeah. Before we move on with cooperation, I want to touch on one of the bullet points. I think it's the fourth bullet point down on the right side of the NCAA column. The expectation withhold student athletes from competition. So the way this scenario would present itself would be as follows. The enforcement staff contacts your institution to provide notice that there will be conducting an investigation into suspected gambling activity involving one of your athletes. But at that point in time in their investigation, they do not yet have firm evidence that an actual violation occurred. It still puts the institution in a position, particularly when we're in the season like now, of making a decision of what to do while that investigation is pending with the athlete as it relates to allowing them to play. There are NCAA rules. One of them is bylaw 12.11.1 that require institutions to withhold athletes from competition that they know or have reason to believe are ineligible. In this scenario, that could be, somewhat of a murky question. So what we've seen is institutions typically taking a more cautious approach where they will, out of an abundance of caution, withhold the athlete from competition, even though there's not evidence to support a violation. And they will sideline the athlete while the investigation is ongoing. And the reason they will do that is because if it turns out that there was a violation and the athlete had played and competed for the institution, it then opens up the institution to additional penalties and sanctions, including forfeiture of games and penalties. So we've seen this play out in other instances. You may have seen some of this news reported publicly where athletes are being withheld from competition pending NCAA investigations. That does not necessarily mean that a violation has been substantiated, but nevertheless, institutions are taking that more precautious approach. In terms of what cooperation typically, could you please go back? What cooperation typically looks like in an NCAA investigation for the institution? Again, these investigations are typically athlete focused. So for the institution, what cooperation looks like is helping the enforcement staff arrange and facilitate interviews of athletes or other individuals on your campus, and collecting and producing documents to the extent the institution is in possession of relevant documents. For individuals like athletes, cooperation would entail sitting for an interview, producing relevant documents, including making cell phones and other electronic devices available for forensic imaging. So the NCAA will make digital copies of an athlete's cell phone, of their social media accounts and their email accounts, et cetera, and comb through that data for evidence of suspected gambling activity. And the cooperative principle, the responsibility to cooperate that I outlined earlier, requires them to comply with those requests. In terms of right to counsel, fairly straightforward, both in the NCAA and obviously in the federal law enforcement context. Any individual party to an investigation has the right to counsel. That would include athletes. Institutions are authorized to pay for personal legal counsel for an athlete in the context of an NCAA investigation. And we've seen that happen in our work with institutions. And counsel, I think, is particularly important for athletes, given the reasons Michael ran through earlier, and the impact false statements can have in the context of a federal case as well as an NCAA investigation, which providing false or misleading testimony during an interview or failing to cooperate can similarly compromise an athlete's eligibility, separate and apart from any gambling activity they may have engaged in. Last, just rounding out this slide here, where the NCAA enforcement staff may get its information that would lead to an investigation comes from a variety of sources, including anonymous or confidential sources. Institutions are obligated to self-report violations or suspected violations in this area. Sometimes integrity services will contact institutions about suspected illicit gambling activity, which would then put the institution in a position to having to report that to the NCAA. Integrity services may also provide that information directly to the NCAA in addition to the institution. And things like media reports or social media activity, the enforcement staff will comb through those types of sources. And they have a dedicated group of staff within enforcement that they call development staff that will network in basketball, in football, and other sports, and work with points of contact and sources in those respective sports to generate actionable information. Michael, on the federal side, you want to touch on where the feds get their information?
Sure, absolutely. So, it's interesting, contrasted with the NCAA, a university would have no obligation to voluntarily cooperate with a federal criminal investigation, in the sense that, let's say a prosecutor in AUSA came to you, you're in the general counsel's office, and they say, look, I want to investigate gambling corruption with respect to the women's basketball team. And I want to interview every single student athlete on that team. And I would like you in the general counsel's office to facilitate those interviews, meaning to set them up one, after the other. I think that is a very fraught situation for a general counsel to find themselves in. If you came to me about that, I would talk you through the pros and cons of doing that. But bottom line is, you would have no actual obligation to do that. There are ways that federal agents have to make universities do certain things. So, for instance, they could serve a subpoena on the university for records, maybe relating to the student athletes under investigation. They might ask to see the integrity pledges that the student athlete has signed. They might ask to see the emails that are stored in that student athlete's account, if it's an account associated with the university. They might also subpoena the NCAA if the NCAA has a parallel investigation into the same conduct. Search warrants are something that federal agents and prosecutors use often, to include getting warrants that allow them to physically seize a target's phone and then search that phone for evidence of the crimes under investigation. Another favorite thing that they do is they will go into iCloud accounts. They will get magistrate judges to issue warrants authorizing agents to take information out of people's iCloud accounts, which, unbeknownst to most people, often includes iMessages that are backed up to their iCloud. And iCloud warrants are usually a rich source of information, specifically text messages that may have been sent a year or two prior. And that's especially important like in the Eastern District of Pennsylvania case, when you're investigating historical conduct, meaning conduct that occurred a few years ago. We talked before about how an agent can never really compel someone to speak in terms of there's no obligation for someone to voluntarily submit to an interview. However, they often do things to try to get people to speak. That includes issuing target letters. This is a very short but very scary letter that a target of a federal criminal investigation could get. It's usually like 3 sentences. It says, for instance, the FBI is investigating you for sports gambling corruption. You may wish to get an attorney, and you may wish for that attorney to speak with me. That is often a prosecutor's way of trying to get someone to come in for an interview to spill everything that they know about the subject matter of the investigation. Arrest warrants, obviously, if someone can be charged, they could be arrested, and that's another situation where the agent and the prosecutor will be looking for cooperation. They might offer leniency in exchange for cooperation. Grand jury testimony. This is the only exception to what I said before about how federal investigators cannot compel someone to speak. You are required to testify in grand jury unless you have a privilege such as the Fifth Amendment right against self-incrimination. That will keep you from giving substantive testimony before the grand jury, but unless you have a privilege like that you're willing to assert, you are going to have to testify in grand jury. In terms of right to counsel, counsel cannot be in grand jury with you when you testify. They're usually right next door. But absent that, someone who is under investigation always has the right to have an attorney of their choosing present for any and all questioning and any part of the process. And that's always important to keep in mind. Where are federal investigators getting their information in these cases? If I had to guess, and it would be an educated guess with respect to the gambling investigations, I think they're getting it from 3 main sources. One, I think they are getting a lot of leads from the established sports betting companies, to include FanDuel, DraftKings. These companies have very sophisticated algorithms that are trying to detect anomalies in betting patterns. For instance, if all of a sudden everyone is betting, a certain team to lose a game in March, that means nothing, and there's a ridiculous amount of money on that team losing by more than 10 points, that is something that could flag the attention of the betting companies, anomalies like that. There are also integrity services, sports betting integrity services that work with these betting companies. I believe that those companies are sending a lot of leads to both the NCAA and also to federal agents. I think federal agents are also going to build these cases from text messages exchanged between and among cooperators. And we went over before how those text messages can be obtained. And finally, they're building a lot of these cases through the cooperation of either witnesses or targets. And I think you'll see that as this Eastern District of Pennsylvania case progresses, that there are already people who are part of this alleged conspiracy who have already pled guilty and who have provided information that will help prosecutors and agents make their cases against the people who have been charged and who have yet to either taken their case to trial or yet to either plead guilty. So those are some of the ways that the feds get their information. And we can go to the next slide, but Mike, I see there are 2 questions pending, and I'm happy to report that they're both for you. So do you want to field those now so they don't pile up at the end?
Sure. So the second question there, are there NCAA regulations requiring prohibited bettors, so that would be coaches, administrators, and athletes, to report approaches to then fix any aspect of a game? So the way I'm understanding the question is, does the NCAA rules require someone who's approached by an outsider to fix a game to report that? The NCAA rules require institutions and individuals to report known or suspected NCAA violations. In this instance, an approach from an outsider like this I think technically would not trigger that bylaw, but I think the expectation, particularly from campus, is that if someone on your campus is approached in that manner, that they are telling someone, and that's one of the things that we were going to talk about later on in the presentation. To the other question regarding NCAA rules prohibiting staff members from using sports prediction markets that are legal in all 50 states. The sports betting operators, FanDuel, DraftKings, BetMGM, et cetera, are legal in 39 states plus the District of Columbia. And the NCAA rules prohibit the use of those things, as they relate to NCAA and sports that the NCAA sponsors. So I would say if there's a use of a prediction market that the NCAA could reasonably construe as a bet or a wager on something in a sport that the NCAA sponsors, my view of that, and I'm happy to try to run that down and confirm it. My review of that is that would trigger the spirit of bylaw 10.3 and constitute a violation, even though it's a prediction market and not a traditional betting app. But both good questions.
Yeah, and thank you. And please keep the questions coming. Our presentation gets better the more questions we field. And that's something I wanted to mention about these betting companies. They can also tell where the bettor is when they are placing their bet. And those are things that they may look at in deciding whether to report suspicious bets to the authorities or to the NCAA. So, for instance, they see that before every college basketball game for a given team, there are bets placed from inside, the practice facility, right before the game. That is the type of thing that might get flagged and investigated. And those bets may have nothing to do with the athletes themselves. They could be placed by the trainer, by a member of the cheer squad, by a student manager. I think it's a mistake to see this as something that only student athletes can do. Inside information of the type that are the focus of these indictments may also be available to other people connected to the team and without involvement from the players themselves. And I think if you're in a general counsel's office at a university, you have to look at this not just as something confronting the student athletes, but also a potential issue, a compliance issue with respect to anyone who might have special access or proximity to the team.
I see a comment from another attendee that regarding the NCAA's interpretation that prediction markets, are viewed as sports wagering activities. Next slide.
And thank you for that.
Yeah, great questions. We'll talk about responding both from the institutional perspective and individual perspective if an investigation, whether it be NCAA or federal, comes to your campus. And I'll address these points as it relates to the NCAA side, and Michael will supplement from the federal side. So for the institution, and particularly for general counsel, your response should keep the NCAA's cooperative principle, which is in bylaw 19.2.1, at the forefront of your decision making. That bylaw is fairly cut and dried, and I think will help steer you in your decision making early on. One of the things that you all should be tracking on if an investigation like this comes to campus is relates to the preservation of records in the institution's possession. Oftentimes, investigators are going to be seeking materials in the possession of the athlete or the target of the investigation, but they may also be looking for records or information from institutions. So if you have document retention policies that could result in spoliation or things like that, you'd want to take a look at those to make sure that those records are being preserved immediately once you learn of a potential NCAA investigation coming to your campus. Also, you'll want to advise people connected to the investigation, which you'll know who those people are early on because the NCAA will notify you, not to do anything or say anything that could be construed as attempting to compromise the investigation. So, for instance, coaching of witnesses. Typically you'll see institutions issue admonishments to entire programs not to discuss amongst themselves, the topics related to the investigation. in terms of the role of the institution in an NCAA investigation, the institution, so that would be your athletics compliance staff or general counsel, are typically viewed as a facilitator for the NCAA's investigative team. So serving as a go-between for the involved athlete and the NCAA enforcement staff. This may get simpler if the athlete has personal legal counsel, but if they don't, oftentimes the compliance officer will be relied upon to communicate with the athlete as it relates to the NCAA's records and interview requests. Institutions will also be expected to help arrange interviews, including arranging interview space. We've talked about collecting and producing documents. They may be asked to help the athlete with collecting that type of material. Also, some related but important considerations for the institution relate to confidentiality and public disclosure. The NCAA has a rule for everything, including confidentiality and public disclosure during investigations. You'll find that in bylaw 19.3.1. The NCAA has loosened somewhat its public disclosure rules in recent years, but they are still fairly restrictive. And basically what they say is that institutions and individuals and the NCAA itself are not authorized to make any public comment or disclosure about a pending case, meaning one that's actively under investigation, until that case has been formally resolved and announced by the NCAA. However, if information concerning your case were to be made public through, let's say, a media report, the party who's affected by that information has the ability to correct or deny the information that is made public. But the scope of that response is very narrow. It would just be, restricted to what was actually reported on. We've seen the NCAA itself be more assertive in its own PR approach. You've seen some public comment from the NCAA, including from the NCAA president, going back to last fall about the integrity cases that they are pursuing. In my experience, that is more of a novel approach than how they've handled these things traditionally, where it's been pretty quiet and under wraps. For the public schools who are in attendance, obviously these types of situations may generate media interest in your campus communities and implicate your state's open records laws. The NCAA does not typically get in the way of an institution's obligation to cooperate with open records requests, but schools will also often keep the NCAA in the loop when those issues arise and when they are responding to such requests. For the individuals, so those are typically named individuals associated with your institution, your athletes, your coaches, your other institutional personnel. The cooperative principle applies to them in the same manner that applies to the institution, and that entails the timely participation in interviews and production of documents. And as I mentioned before, the institution will oftentimes be expected to help facilitate the NCAA's requests and even encourage the cooperation of individuals, including folks maybe on the periphery of the institution, like fans and boosters, were they to be part of an investigation. And again, the confidentiality rules surrounding protecting the integrity of the investigation apply to the individuals just as they apply to the institution. So if you've got athlete and coach talking about a pending NCAA interview, that could expose both of them to a failure to cooperate charge from the enforcement staff. As Michael touched on earlier, oftentimes it's not even the underlying act that is the most troubling or harmful. It's the act of trying to cover up whatever's going on. Michael, anything on this point before we move on to best practices?
Yeah, just a few things, Mike. Thank you. So, as I said before, unlike the NCAA context, the institution is not obligated to voluntarily comply with federal law enforcement, requests that are not subpoenas, which are in fact court orders. As a practical matter, and in certain situations, the institution might want to be cooperative. It's really a case-by-case determination, and I know that's kind of a classic lawyer's dodge, but it really does depend on what the given facts are. Certainly, if you receive outreach from federal law enforcement, you should be preserving records. You should be, doing the equivalent of litigation hold notices. You should make sure that whatever records are within the possession of the university are not destroyed. In terms of media, I think that's an important consideration because these sports gambling corruption cases are heavily covered in the media, but at the same time, you have student athletes and coaches who face the media after each game. And so I think if you're in general counsel's office, you have to engage with your communications folks and make it clear that no one is to comment on any report of an investigation into alleged sports gambling corruption. And that's something that probably has to be reiterated over and over again because the media is often face to face with these athletes and these coaches. Again, presumably after every game, and in some situations before major tournaments. The only other thing I again wanted to stress is that I've seen it said, and it's a good point that the gambling indictment that we know about from last week focuses on maybe smaller schools at non-major conferences, and you might be from a huge school with a huge program in a huge conference, and you might be saying to yourself, well, I have nothing to worry about. But I want to reiterate my point that some of these charges, some of these investigations may focus not on the student athletes, but on people connected with the team who might have access to non-public information that they use to bet on. And those people could be associated with a quote unquote, smaller team in a quote unquote smaller conference, or they could be associated with a huge basketball program at one of the major conferences like the ACC or the SEC. And, if I'm general counsel, I'm worried not just about the student athletes, but about anyone connected to the program. And I think that plays into some of the recommendations that we make, which are the next slide.
So you may be, I'll start, Michael. You may be asking, what you can do today in this area. In our experience, the schools that handle these types of issues the best are the ones that prepare and practice and educate today on an ongoing basis. So first and foremost in my mind is making sure that the people on your campuses who need to be informed of these issues when they arise are notified right away. And that needs to include the general counsel as among the first to know. Now, that's easier said than done. Your campuses are large, thousands of people, several different campus units. So that requires a really concerted effort to create broad institutional awareness, and certainly within athletics, of what suspicious activity even looks like, and then what to do with it when someone spots it. So if one of your academic advisors is in a meeting room with a group of athletes over study hall and overhears them talking about betting, or sees an athlete with a DraftKings app open on their phone, that needs to be reported up the chain of command immediately and not written off as something harmless or just, guys shooting the breeze. Your athletes may be contacted directly, and likely are in some situations, by outsiders, including bettors. And anytime that happens, whether they respond to the outreach or not, they need to report it. The bettors will simply go, if they don't get a response, they'll simply go to the next person on the roster. And if no one says anything, sooner or later, they're going to get in touch with an athlete who does respond and is receptive to the outreach. These outsiders are praying that no one says anything so that they can kind of go down the roster. So Next, after creating that broad institutional awareness, we would recommend asking whether your institution has a formal plan in place on how to respond to these issues. Is there a dedicated, capable team of professionals in place on campus? Are there roles defined? Is the general counsel involved in that policy and have insight into that policy? And if not, they certainly should be. Um, and last, what does your institution do to educate and train both your employees and your athletes? Is your education and training as simple as a paragraph in an employee handbook or a student athlete handbook? If so, that's probably not going to cut it. With the prevalence of sports betting in our culture, and again, expansion across the country, sports betting should be an area of emphasis among your employees, particularly in athletics, and certainly among your student athlete populations. And I think it's incumbent upon the school to give these individuals the tools they need to both identify suspicious activity and respond to it effectively and in a timely fashion. And the best part about all of that is that, at least in the NCAA context, there is a real incentive for the institution to do so. And specifically, the NCAA rules and procedures have codified rewards for institutions that can demonstrate that they have provided meaningful education and oversight in the area of sports betting. For instance, if a gambling investigation involving one of your athletes were to occur, the institution will certainly have a role in that, and there may be an institutional violation as part of it. But the culpability for the institution can be downgraded significantly compared to that of the athlete if the institution is able to demonstrate that it provided contemporaneous education and oversight in these areas. The NCAA rules actually allow for an institution's case to be processed as a secondary or level 3 violation, even if the athlete or the coach has engaged in major misconduct. And all that needs to be documented and need to be persistent.
And Mike, you have a question there.
Sure. Question here. What about athletes who mention information about themselves or teammates to their own family members? Is that problematic? If I'm understanding the question, is an athlete divulging team-specific information to a family member? I think it's reasonable to expect an athlete to talk to a family member about what's going on with the team, challenges they're having, etc. But if there's some reasonable belief that the family member is going to use that information in the context of betting activity, absolutely that should be of concern, and that should be something that the athlete should be reporting. So I guess it depends on what's the athlete's understanding at the time of why they're sharing that information and to whom and to whatever that person's going to be doing with it. I hope that answers the question.
Yeah, and it's interesting. Some of these indictments treat non-public information about sports almost as if it's like insider trading. So their theory of the case, Mike, at least as I understand it, is that when someone places a bet with one of these major betting companies, they're affirming or certifying, I guess it's in the terms of conditions, that they are not trading on non-public information. And so, an information about an athlete being injured or about someone else being in the starting lineup in a given game, that is now, at least based on these untested theories, that is now being seen as something that would be illegal to trade on if it's not public. And to answer the question, and this is me, more or less just thinking out loud, if the athlete is just calling home and telling mom or dad that, oh, my friend on the team just got, injured, and that's not something that's been publicly reported yet, I don't see any problem with that if it's just a normal phone home conversation where the athlete's just talking about his or her day. As Mike said, context is important. If the athlete is actually telling that family member about that injury so that that family member can then place a bet on the team to not cover the spread that night, then that is very problematic, and it's something that ought to be reported and looked into. So context is really important, and this might also go back to the need for education, because if athletes and those close to the team have an understanding as to what's allowed and what's maybe in a gray category and what is in fact not allowed, you might be able to eliminate some of those gray area situations, such as the athlete calling home, telling mom or dad about a friend's injury. Maybe the policy should be that athletes should not publicize injuries before they are announced publicly. Again, this is something that you can take into account in deciding your educational policy, your compliance policy, and just one more thing to think about. And just to reiterate some of the points that Mike said, I think it's very important that everyone connected with the team understand that any communications with federal officials should go through the general counsel's office. Ideally, no athlete should be talking to a federal agent without first notifying general counsel's office. That somehow has to be built into the clear and well-known reporting channels that we're talking about. Athletes and those close to the team should also understand that they have a right to counsel before agreeing to speak with an agent. If an agent wants to speak with them, maybe the response is, sure, fine, I'd love to, but I want to first consider whether I need to have an attorney present when I speak with you. Because an attorney can not only advise the person and could also keep them from making false statements, the attorney could also get assurances from the prosecutor that whatever is said in this interview won't be used against the person who is being interviewed, because those protections can exist in certain situations. And finally, I just think there needs to be a broad awareness of suspicious activity. Again, not just with respect to the athletes themselves, but with respect to people close to the team. If you have a trainer on staff who is known as a prolific bettor, who always has the FanDuel app open on his phone, who's betting right before games, that is something that needs to be addressed right away, because it could be the subject of an NCAA or federal investigation. And, you know, it's best to try to nip that in the bud before it ever grows.
Next slide.
Oh, and someone has a citation for maybe
I think we were looking for someone was asking for the citation of the interpretation related to prediction markets. And I believe that response was in response to that question. We'll also do some digging, and we can pull that interpretation. We can try to distribute it to the mailing list who signed up for the presentation.
That's great. And I think if we go to the next slide. So we have, maybe we have a few more minutes, but we're happy to take any and all questions at this time. If people have any more questions they want to ask of either me or Mike.
And while we're fielding those, I have a couple points I just want to talk about. A lot of what we've seen in terms of the athletes who were involved in these NCAA investigations, they're transfers. So by the time the NCAA or even the Department of Justice is investigating the issue, they're at the new institution, they're at your institution, but what they're being investigated for relates to conduct that occurred at a previous institution. So this relates back to the vetting that your coaches are undertaking of transfer prospects. The transfer portal windows are getting shorter and shorter. I think the one for men's basketball is 2 weeks. So these are very finite windows of time in which coaches are recruiting dozens of players across the country at any one time. So I think it would be important for your athletic staff and your general counsel's office to help the coaches with how they go about vetting their transfer athletes, and including potentially explicit questions about connection to gambling activities. A lot of these athletes, whether they're incoming or transfers, are signing rev share agreements with your institutions. Um, the contracts that I've assisted on will have, for instance, what we kind of loosely refer to as morals clauses, where involvement in this type of gambling activity can be grounds for termination. Do your rev share contracts have such provisions, again, to protect the institution? If not, you might take a second look at them. In terms of integrity services, these are outfits that monitor betting trends and betting activity across the country. They have relationships with sports books and sports betting operators. They can identify abnormalities in betting activity. Some of what we saw in the indictment in the college basketball cases were hundreds of thousands of dollars on really obscure random games that post an obvious red flag to regulators. And those entities will work, hand in glove with the NCAA and the sports betting operators. So they're very sophisticated. The people who are engaging in this activity maybe aren't as so, and they're going to get caught. So, I think that can be, in one hand, reassuring to institutions that there's going to be some help out there, real savvy expertise. But at the same time, I think it's important it underscores the educational component that we were talking about earlier. And then the prediction markets that are seeking entry into college sports, this is going to be a developing story. I know you've seen the NCAA president and the NCAA generally come out strongly against this type of activity and calling on federal regulators to shut down prediction market activity into college sports. But for now, we're seeing that being kind of a growth space. And again, I think whether it's traditional sports betting activity or activity involving prediction markets, it's all concerning, and it all should be part of your education and your oversight efforts on campus.
Also, keep in mind, Mike, that a lot of gambling still takes place through unregulated markets and businesses, meaning the neighborhood bookie is still very much alive and well. And in fact, some of these indictments relate how some of these bets were placed with such people, and such people are also tied to organized crime. And also there are betting companies that are overseas in foreign countries. They operate through the dark web. They are not regulated. So a lot of betting activity takes place outside the purview of these integrity services, which might give confidence to these bettors that, in fact, they won't get caught. And this is, unfortunately, something that's here to stay. I doubt that the combination of federal law enforcement, NCAA investigations, and these mainstream betting companies are going to stamp out college sports gambling corruption. And the best thing that council can do is try to recognize the risks, plan ahead for them, and act accordingly.
Next slide. Oh, I think we're done. So we're a few minutes over here. Really appreciate everyone's attention and attendance here today. This is our contact information. You're welcome to reach out to Michael or I anytime if you have questions or if something wasn't quite clear during the presentation. And depending on interest, we may be making this a recurring theme in future webinars. So anything to add before we wrap up, Michael?
No, thank you all for your time, and happy to answer any and all questions offline.